That is a reasonable expectation because although it is a public place, the individual,
Well, if you're in a public place, don't you have a lessened expectation of privacy?
you do have a less expectation of privacy. What I'm contending is that although there is no reasonable expectation of privacy, there is a reasonable expectation that your actions won't be remembered 20, 30 years down the line, or that the exact footage will be kept for individuals that aren't actually acting in criminal activity. This could be compared to the...
Can you cite any case law describing a constitutional right to governmental forgetfulness?
Though there is no constitutional right to governmental forgetfulness, it is essential that we adopt this idea into our protection of the Fourth Amendment, because with the advances in technology, it is clear that while this new technology should be used in immediate circumstances, this information and data should not be kept by the government for years to come.
You mentioned in your opening statement private data mining companies. When you're talking about private data mining companies, does the Fourth Amendment even come into question? If your answer is yes, why? And if your answer is no, why not?
Although the Fourth Amendment does not affect private companies, the fact that these private companies can data mine information for the entire citizenry and everybody in America makes it applicable, because when the government obtains
Who does the Fourth Amendment protect you against?
the government.
Is a private company the government?
No, however, when the government obtains this information submitted to the private companies, this is when the Fourth Amendment must be considered. Because, as is current by case law, in the case of Smith v. Maryland, information submitted to a third party has no reasonable expectation of privacy. However,
But who ultimately did that information wind up in front of?
the government.
So then your argument is if that third party or that data mining company, are you telling me that data mining company then gives it to the government, then it invokes the Fourth Amendment?
yes, the government should be regulated in the amount of information they can obtain by these data mining companies, because the technology is so expansive and obtains a variety of information of individuals.
If we simply allowed the government to bypass the Fourth Amendment by employing private companies to do their searches and seizures for them, then we would be eroding the core of the Fourth Amendment, which was designed to protect us from such general searches that's in the colonial times and general
The
warrants.
Constitution protects us, protects our person or place and things and papers. Should something that the founders could, or the framers could never have thought about, such as iPhones, should that be extended to include papers?
Yes, it should be extended to a certain extent to include an individual's effects, because although it is new technology and although it takes a different form, the development of new technology has previously been seen, and the interpretation of Fourth Amendment case law has had to adapt to new technology, as when telephones were invented and the possibility of wiretapping, with the cases of Olmstead v. United States first, which did not uphold the right of privacy of an individual in a telephone booth, which was then later overturned with the case of Katz v. United States, which established the idea of a reasonable expectation of privacy. So similarly, with the development of newer technology now, such as an iPhone, there should be a certain amount of privacy within that context.
I'm still mulling over a constitutional right of governmental forgetfulness. As I understand your position, you see no constitutional violation. Well, let's put it this way. You're not claiming that a person has a reasonable expectation of anonymity with respect to one's physical presence in a public place, are you?
No.
All right. So what is bothering you is the possibility of the government collecting an aggregation of information regarding your presence in various public places. Is that right?
Yes.
When has the government remembered too much? How do you measure that?
Because we have not seen this technology for such an extensive period of time and the possibility of keeping these records yet for such a tremendous period of time, there has not been necessarily the same precedent established yet.
Well, what sort of test would you suggest? I mean, if you were an attorney arguing for the recognition of a right of governmental forgetfulness, the court would, I guarantee you, ask you for a suggested test by which that right could be implemented and measured. What test would you suggest?
There should be a statute of limitations on the amount of time that the information can be withheld by the government. As, for example, murder has no statute of limitations. Therefore, this information is necessary to be obtained in order to prevent a future occurrence.
We do not contend that no technology should be used to aid law enforcement. For example, with surveillance cameras, the footage gained from these technologies should be used in immediate circumstances when trying to solve, for example, a kidnapping. However, when the statute of limitations runs out, the footage should no longer be used to solve crimes.
How would that work with something like the footage from the Kennedy assassination?
Because that would involve a murder, and because there's no statute of limitations, then that footage would be able to be kept indefinitely. And as the trial already took place and as they already determined who the murderer was, then this issue has already been dealt with. So there's no threat as per the limitation of this particular record.